Hi, welcome everybody. This is a webinar from Institute of Internet and Just Society. Today we'll be discussing various country reports on privacy and COVID-19 related issues regarding privacy. Of course, we have many esteemed panelists from Brazil, Croatia, Netherlands, and Philippines. I am Vinita Kavij. I'm a lecturer at Jindal Global Law School. I would be moderating the webinar today. And now I'm going to give the floor to the panelists. So how about we start with Daniel Becker from Brazil.
Thank you for your nice introduction, Nitka. I'm Daniel Becker. I'm partner of the law firm here in Brazil called Lima Ferguson Advogados. I'm also the I'm also the director for technology of the Brazilian Center of Mediation and Arbitration. I've been studying and working with privacy and data protection for a couple of years now. And the most interesting part of this report regarding Brazil was that last year was really busy for data protection. For instance, it was the time when the Brazilian Supreme Court decided that the data protection is a fundamental right. So we had a ruling on that. Also, we had our Brazilian data protection law entered into force on August 2020. And we had, of course, several needs for virtualization of the public services, such as the courts, also welfare, what they call emergency aid. We had to include several people in need so that they could receive like an amount on welfare. And also we had to deal with these apps developed by the public sector to prevent or to help the contention of the virus. And all of it, yeah, mixed, we have like several topics to cover. And to make a long story short, that's it. So we can go deep into it in the next round.
Great. So let's now switch to Ms. Lina from Croatia.
Thank you. Thank you for having me here and for inviting me to present my research. My name is Alina. I'm a Croatian lawyer. I work as an associate for a global law firm here in Zagreb. My work is primarily focused on data protection, IT, new technologies, but I also work with tech transactions and media. So regarding the research and the main issues here in Croatia caused by the pandemic, I would say that the main problem and the source of all other problems, related problems, is the lack of COVID-19 related data protection or privacy law, or in general any other legal document such as binding order or a decision that deals particularly with the increased processing and surveillance of Croatian citizens. I mean, of course, we are in the EU and GDPR applies, but due to the panic that pandemic caused, the data and privacy protection have not been among the top priorities, let's say like that. And the lack of specific guidance contributed to oversighting the massive data collection and the problems that it has caused. And with the lack of any specific guidance, really a great burden was on the Croatian Data Protection Authority, which was also quite inactive during the pandemic and has released only 4 opinions in total. Some of them were really useful, like for processing in the employment context and for temperature measurements, but overall, they have not contributed sufficiently to regulate the situation. Also, I would like to mention we had released 2 digital technologies for dealing with the pandemic. So one was a contact tracing application, similar to majority of applications of apps in Europe. which also raised certain doubts, but mostly the doubts were about giving misinformation in the privacy policy. But apart from the contact tracing application, we had a very, very interesting and alarming tech tool, which is like an AI digital assistant, which can be contacted via WhatsApp network, and users can directly communicate with the AI, which is intended to give health advice, or advice like go and see your doctor. Yes, these are the COVID symptoms. You should see your doctor. And while the intention of this technology, I think it's really good, and its intention was also to lessen the burden of the epidemiologists and public authorities when the panic spread around, but there is no sufficient guidance or regulation of the personal data protection and collection via the AI assistant. And to sum it up, I would also like to mention the non-response to increased cyber threats in Croatia, lack of any public alertness or guidelines from the authorities. So overall, the main problem really is the lack of regulation. Thank you.
Right. Thank you. Thank you for that very brief yet succinct summary of your report. I think we can now move on to Netherlands. So we have Ms. Van Gils from Netherlands to present her report and her ideas of privacy issues in Netherlands.
Well, thank you for inviting me to present my views. I do not have the extensive experience as the other panelists. I just recently graduated from the University of Amsterdam and University of Leiden in both criminal law and public international law. The Netherlands. My biggest concern relating to the rights of privacy and corona-related measures in the Netherlands is data protection and data collection. So the Netherlands introduced a tracing app this fall called Corona Reporter. And the use of the app is done on a voluntary basis, and the design of the app is well, technically great. The app does not use any location data or GPS, but it instead detects whether the user was nearby another user by means of Bluetooth. So the closer two users are to each other, the stronger the Bluetooth signal gets. And this way the app does not recognize the identity or the location of the user of the app. And data such as name or telephone number are not used or stored. So when a person tests positive for COVID-19, the municipal health service provide a code which then a person can share on the app, again on a voluntary basis. Another user receives a notification on the app if they have been in the proximity of the person who has tested positive for more than 50 minutes. So the design of the app is generally great. But for me, a concern is that the municipal health service, which is tasked with testing and contact tracing, lately there have been severe leaks in this organization. Information of millions of citizens is being traded on the internet, and not because of a hack or anything, but because of the system is just outdated and being misused even by employees. A lot of employees who work there can export any information. Almost all employees have access to most information, even when it's not necessary for their work. This is already concerning, but instead of taking action after this leak, the Minister of Health in the Netherlands announced that he thought, and I quote, "Ultimately, there's no cure for this type of crime." However, there wasn't, like, as I said, a big hack or anything. It was just the system is outdated and not safe and secure. And this negligence or unawareness or maybe even ignorance could also be seen last summer when restaurants and cafes were still allowed to be open. in the Netherlands. A measure was imposed that required bars, cafes, restaurants, and entrepreneurs in contact professions to ask visitors to register their names and contact details upon arrival to the establishment. This info could then be used by the same municipal health service for its contact tracing endeavors. And the same establishments were also required to ask visitors as to the status of their health, whether they had any symptoms of COVID. So the collection of this information had to adhere to the standard of the GDPR because the Netherlands is in the EU, so the EU General Data Protection Regulation. But in practice, this rarely happened because most entrepreneurs don't understand or don't know the legal requirements for the storage and processing of data. For example, the collected data must be stored safely and should only be accessible to the municipal health service. But in practice, registration forms on clipboards were being passed around a restaurant where people could leave their information, and hardly any establishment explicitly pointed out the voluntary basis of responding to the health query and registering the contact details. Also, the health status of visitors was sometimes stored in online booking systems, which is also not allowed. So there was a lot of unawareness and negligence in this situation, and the government hasn't really done anything about it. So that concerns me because during this pandemic, more and more data is being collected. Schools and universities were closed for a long time in the Netherlands, and because of that, they use online surveillance software when taking tests. And I mean, a lot of students in schools and university are underage, so online surveillance software can, breach their privacy. So it is very important that the safety standards are up to date and people also understand the dangers of collecting data and not storing it safely. So therefore, I think that is the largest concern right now in the Netherlands, just unawareness in how to deal with this kind of data collection and storage.
Thank you. Thank you so much, Ms. Van Gils. Let's move on to Dr. Angela from Philippines.
Hi, good morning, good day, or good evening to everyone. So I am Dr. Angela Aguinaldo. So I'm a Philippine lawyer now based in Germany, and I was a doctoral researcher in the Max Planck Institute for the Study of Crime, Security, and Law, and International Max Planck School for Comparative Criminal Law. So my report about the Philippines, I approached it in a securitization context, because this phenomenon of securitization of COVID-19 has been an apparent phenomenon in Southeast Asian countries. So, and basically securitization means that you take COVID-19 as a security threat. So you use it as a justification for implementation of stricter measures or stricter measures that somehow encroach on human rights or civil liberties of the population. So I discuss in my report about different violations or reported violations of human rights that arose from the securitization approach by the Philippine government. But in particular, for the purposes of our discussion today, for the privacy and data protection, there are questionable measures adopted by the Philippine government that trample on or have repercussions on data protection and privacy. So we could see that aside from the curtailment of freedom of movement, it has been used that the measures against COVID-19 has been used to encroach on the privacy of one's home or one's abode, especially those of alleged detectors of the government or activists. So this is encroaching on their privacy. At the same time, you can see privacy repercussions or data protection repercussions in the contact tracing app that the government has enabled for the citizenry to use in the Philippines, as well as the emergency powers that was given to the executive department to take over public utilities and and hospitals and medical facilities, which of course these facilities are holders of data. And since there are no concrete parameters, it encroaches, or there's a danger that there will be a misuse and abuse of the powers given to the government. And this has been apparent from the reported violations that, yes, the law might be clear or clean on the books, but in the implementation itself, it's quite scary because they are using these measures against their enemies. And at the same time, I also concluded in my report that this securitization of COVID-19 in the Philippines, as well in Southeast Asia, has become this kind of fog of war that enables catalysts of delinquent behavior from government authorities. So they have used the quarantine measures, the lockdown measures, and other measures concerning COVID-19 to their benefit, to oppress or repress people who have been speaking against the government or have been doing things that the government doesn't like. So yeah, so that was the report that I made for the COVID-19 responses in the Philippines.
Thank you. Thank you so much, Dr. Aguinaldo. So I think we can begin with a conversation on 4 major areas, and then further we can figure out what are the things that we need to discuss. I think one major overlap that we see in all of these countries that are being presented today is the issue of apps, right? And beyond apps, we also have this issue of the ambiguity in law, or the gap with what the law is saying and what the practice actually is. We see that in Netherlands, Croatia, Brazil, and Philippines, right? Apart from that, we also have certain, have I mentioned apps? Yes.
Yes.
Okay, so yeah, certain emergency aid issues that Mr. Becker also highlighted. About how to basically provide for the people who really need to be provided for, however you're handicapped in certain ways with respect to how to reach the people who really need to be reached. So let's begin with these 3 overlaps, and also with the 4th overlap of legitimacy in law, right? So we have Philippines over here with the state of emergency with respect to COVID-19. We have Croatia, where Ms. Elena has specifically told us that there is no real direct specific law with respect to COVID-19 protections or COVID-19 liberties that a government can take with respect to data protection. And I'm so sorry. We also have Ms. Van Gils, who's argued in her country report that within Netherlands, all COVID-19 related privacy issues or data protection limitations on your privacy were taken through ordinances, which as an argument could be made that they're not in fact legitimate in law as a proper bill or an act would be, right? And we also have Mr. Becker letting us know exactly how the data protection law was passed in the middle of the pandemic, and how everything was done regarding emergency aids, apps, and all the things that followed before the law was passed. So we have all of these 4 major overlaps, and I think we can begin when we begin with the issue that I think all of us do deal with on a daily basis, the data protection with respect to apps, right? So I invite Mr. Becker to tell us about Brazil's experience with respect to apps in particular, and the data protection issues that arise from it, and then we'll go clockwise.
Okay, it's a very interesting question because we saw a lot of violations by the public sector of the data protection law. But to understand it, we need to look to Brazil and to Brazil legal system as a whole. Differently from Europe, for instance, we did not have a data protection law, and data protection wasn't a thing until 2 or 3 years. Brazilians traditionally doesn't know the value of privacy and data protection. And of course, it also applies to the government. So a lot of these apps were developed without thinking on subjects like privacy by default or privacy by design. They weren't transparent, and I think this is the main issue here in Brazil, because since we did not have this culture of data protection and privacy. Also, I mean, like the data subjects also didn't care until now. So the law is still just a correction, it wasn't passed last year. It entered into force. It was passed on 2018. So it had like a 2 years of, we say vacatio legis. It's a period that the law is stayed. It happened with the GDPR also. You have 2 years, but during this period, the government didn't adequate itself to the law. So I think this is the main issue. Also, our data protection authority, even though it was created 2-3 years ago, it's still very slow. It didn't enact any regulation already. It just opened some public hearings to gather information on incidents, security, cyber incidents, and stuff like that. But it didn't regulate the data protection law, how it should apply to the government. And I think this is the main issue here in Brazil. And the problem, I think, of course, we have someone to blame. We have okay, the government is violating our data protection law, but I think we are still understanding how this law will be applied here in Brazil.
A specific question with respect to the data protection lacuna that you've described here generally with respect to, let's say, the specific app that we're talking about here, right? How would the app be violating somebody's data protection rights? Because as I understand it, there was a certain voluntary nature that the app has when you are providing data, or is there, so when you are providing data, do you have, let's say, certain steps that you have to take on the basis of different consents that you have to provide? So let's say I can use the app. So that what happens in India is we have an Arogya Setu app, right? I can use the app. I can see how many people have been vaccinated. I can see how many people around me are in danger without giving my data. So I have consented to use the app, and I have consented for my Bluetooth to be on while they use it. But I haven't further consented to provide more of my data, only my current location for that temporary period, right? So it's limited consent at every stage. Not that it's a perfect app in any way, right? But I'm trying to figure out whether you have a similar idea of an app with respect to the SUS app. Am I right?
Yeah, exactly. Sorry, I was a little bit generic with the critics, but I think the first issue is transparency. We don't know how this data is used and which data is used. We know because we study it, but I mean, like the general public doesn't make any idea. So they don't have any steps that show how this data should be used, where this data will be stored. So I think this is the main issue. The necessity, we have the principle of necessity, but comparing to the GDPR, they say minimization. It's the same principle basically, and it's not clear whether these all of this data is needed for reaching the purpose. And I think this is the main issue with the SUS app: transparency and necessity. And of course, security, we don't have any clue because still, since we don't have transparency about the security measures that are being adopted, we can't say anything about security. But since we have a lot of leaks last year involving the government, we can presume that it also affects the SUS app, because we have had a huge leak on the Ministry of Health last year, and the SUS app was developed by the Ministry of Health.
That clarifies exceedingly well exactly what I was trying to figure out with respect to the entire lacuna that you keep pointing out, right? Okay, so I think we can now begin with Ms. Selina with respect to Croatia's experience, specifically with respect to apps and the data protection gaps with respect to the apps.
Yes, thank you. So as I mentioned, we have two apps, so two digital technologies. So the first is the AI assistant, contacted via WhatsApp network. So the thing with Andrea, that assistant, is that it was released in March 2020, so literally at the beginning of the pandemic, and no one actually was concerned about the data protection. It was some sort of a shock in Croatian society, and the panic spread, because of the COVID. And I mean, 2 weeks after the first case, we were half quarantined. So people weren't talking about Andrea and data protection and what kind of data is collected. Or I don't think actually that Andrea ever, that the government ever published the official privacy policy for Andrea. So there was a complete lack of transparency with regards to that app. And also, as Andrea is an interactive tool, so you are communicating interactively with the AI. It is really challenging to identify and to track all data categories that are collected and processed by the app. But Andrea is not really used anymore. So people were using it in March or April and May in 2020. And then in July, we introduced the real contact tracing application. So it's called Stop COVID-19. And that is the application that is developed on the Google and Apple platform and operates via Bluetooth. The app is completely voluntary. It's decentralized, so it does not store data on one central server, but the data is stored on your own mobile phone. So only in case of noted infection and registered infection, then the data is being transferred to the central server in order for the server to inform all contacts about the possible infection. And also, the app does not collect location data. It operates on proximity data. So the app, I mean, that's what they claim. The app does not know your location, nor does it process your location, but only proximity data. I think that it was 2 meters or 1.5 meter in order to register the two phones. And then you're being registered in the database of that other person's mobile phone with whom you were in contact. Regarding the app, I tested the app myself, so I downloaded the app and was trying to figure out how it functions, whether identification is indeed possible. And what I found very alarming is the miscommunication and misinformation given in the privacy policy accompanying the app. And the main problem was the nature of the data collected, because government and the Ministry of Health claim that the data is anonymized, which I wouldn't agree with, because if data is anonymized, that means that you cannot by any means identify the person. Where data is pseudonymized, then you can, with the use of additional data, which is precisely the nature of data processed via the Croatian contact tracing application, because there are ways of identifying, although the app only collects proximity data and your key, so your mobile key, which is used to communicate with other applications. So there are definitely ways of identifying and tracking the person which uses the app. And you can do that, for example, either like without the use of any kind of technology. So if you know that you as a user have been in contact with only 10 people in the last 10 days, and you know that only 5 of them have the app, and you get the notification that one of them is infected, I mean, you can really figure out quite soon which of the person you were in contact with is the infected person. And also there are also technology tools for so advanced technology which can track the broadcasting of devices, can easily in a room identify which mobile phones are broadcasting the Bluetooth. and which of them have the app installed. So I think that although really, I would say that the Croatian government really endeavored to, make this app as privacy friendly as possible, and it was actually the best solution. So it was completely voluntary, it was decentralized. They really put a lot of effort in it, and it is mostly GDPR compliant, the app. But still, that uncertainties and miscommunication and disinformation, I think that is the worst problem. Because if someone claiming that the data is anonymized, that means that no one can ever identify you as a user, which is not true. So that was the main problem. And there is also one thing worth mentioning with the app, and that is the question of how can actually app users exercise their GDPR rights towards the ministry, which is the data controller. I will not go into specifics. This would be too long for that, but there is a specific article in the GDPR that deals with processing that does not require identification. It's Article 11, and it's not quite clear how to interpret that article. And what the ministry actually did was they claimed that as the main purpose of the app is not to identify users. Therefore, if a user wants to exercise its right towards the ministry is not in the obligation to collect any additional data from that user in order to identify a user and to enable him or her to exercise its data protection right, which is the wrong interpretation of that article, because that the GDPR regarding the processing that does not require identification claims that yes, you as a data controller are not obliged to collect additional data in order to identify a user. So you are not obliged to put additional effort, to collect additional data by yourself. But if a user is willing to provide the additional data in order for you to be able to identify that user, in such case, the ministry or other data controller would be obliged to collect that data and to enable the identification of that user and the exercise of his or her rights. So I really think that the aforementioned misinterpretation of pseudo-anonymized and anonymized data, together with the lack of clear guidance and the actually ability to exercise your rights, are the two main issues with respect to Croatian COVID app.
Okay.
Thank
All
you.
right, that's very, very eloquently put, Miss Alina. I would invite Miss Vangels to further react to this Croatian situation regarding this transparency and misinformation, and of course the misreading of the GDPR, considering you're of course also obliged to follow the GDPR.
Well, I think the Dutch tracing app does comply to all GDPR requirements. Before it was launched, the government sought advice from the Dutch Data Protection Authority, which advised that there should be, the use of the app was based on consent, on if users wanted to share the information with the app, which is of course used by government. So the Dutch Data Protection Authority thought that consent wouldn't be, the legal basis wouldn't be sufficient because it is a governmental authority that uses the information shared on the app, and it is a quite far-reaching measure. So therefore, the Public Health Act has actually been amended in the Netherlands to contain provision on the use of tracing apps. So I think that's a really, really good, and it is now even a misdemeanor if you force someone to use the app. For example, if an employer says you have to use the app in order to be able to work at this office, that results in a misdemeanor, which is even punishable by a maximum of 6 months detention or fine, which I don't think has happened yet. But I think the Dutch government does put a lot of importance on the data protection of the app. It's very clear in use. If you open the app, there are immediately frequently asked questions in like the first screen, and one of them is about data protection. So the privacy statement is also in very clear language. It is based on privacy by design. So I do think that the Dutch Corona tracing app is done really, really well. I am more concerned with the municipal health agency that uses some of the information. But I think the app in itself is done really well.
Thank you so much. I think we can now move on to Dr. Angela to further react to the panelists and also, of course, let us know their situation.
Yeah, so I think you asked also earlier about the state of emergency. So I would like to address that first.
Yeah,
so
please.
It's unique. In the Philippine situation is unique that the president needed to declare a state of national public health emergency and calamity in its 2 consecutive proclamations by the executive department to enable the executive department or the president to implement the provisions of 2 statutes with respect to notifiable diseases and health events concerning public health emergencies, as well as the law on disaster risk management and prevention. So under the Constitution, there are emergency powers that can be exercised during a state of national emergency or in times of war. So certain provisions are enabled when there is an national emergency. And I think this is the basis for the state of emergency, so that the president can also exercise emergency powers in addressing the COVID-19 measures. And this was also enabled by the Congress itself, the repository of these emergency powers, when they enacted the so-called Bayanihan as One Act and the Bayanihan to Recover as One Act, giving the president in a limited time period emergency powers to take over public utilities, to control the economy, and to address the COVID-19 concerns and issues that arose in the country. So that is the reason why there was a state of public health emergency. So for the president to exercise the powers needed to address the COVID-19 problems. As regards the question on the apps, there are many criticisms about it. So when I wrote the report, actually, it was just belatedly after the cutoff period for the report. That was when the Stay Safe app was really implemented and enforced, and the problems that arose from the usage of this app has been put into light. So the Stay Safe app, so we in the Philippines, we have this so-called interagency task force for the emerging infectious diseases. So they are the main task force under the executive department that addresses this COVID-19 measures. So they issued recommendation number 95, which endorse the use of Stay Safe app. It is questionable, and it's not there again is the issue of transparency, which I think Daniel also mentioned earlier, and the other Alina and Meryl, the transparency issue, because it wasn't really sure why this app was chosen. It's a private entity owned app, a contract facing app. So normally in the Philippines, you would have this government procurement rules about bidding, etc. And what standards were used by this task force to choose this app. So, and then they, in this same proclamation or recommendation number 95 from the IATF, they mentioned that all data used by or possessed by the Stay Safe app or the company that owns Stay Safe app will be transferred to the DOH. So there were many privacy advocates or criticism from the people and asking, how do you process this data? Because actually the Philippines has Data Privacy Act of 2012. Under this act, we have the right, to have control over the data flow, the custody. So at the heart of data privacy is, the control and, the control over who will control the processing, the use, the gathering of this data, destruction of this data. My question now is that, did the government even ask permission, or the owner of the app, the private entity, ask permission from the users whether their data can be transferred? Because It is at the crux of the Data Privacy Act to ask for consent or and give notification to data subject from data subjects before their data can be processed even further or for other purposes other than the collection of contact tracing. So there has been many issues regarding this stay safe, and there have been reports nowadays that this contact tracing app, supposedly mainly used for COVID-19 contact tracing, is being used for red tagging or against detractors of the government. So there is questionable transfer to law enforcement, which is very questionable. And if you follow the raison d'etre of the Data Privacy Act, that is not allowed. You need a warrant or you need the consent of the data subject before you can transfer it. And interestingly enough, in the Philippines, so mainly it is Stay Safe app, which is endorsed. But I have been privy to information that in some provinces, in local governments, instead of using the Stay Safe app, there have been provinces who endorse a different contact tracing app. And this is related to, political dynasties and, the padrino system in the Philippines. The contact tracing apps owned by a businessman, friend of a politician. That's why it's being used. And then there have been reported breaches of data privacy and data protection using these apps because it's the information is leaked, is processed against their consent. So it's very. I mean, it's an example that even if we have something beautiful in law, this is a situation, a microcosm of how implementation can change. So yeah, that is very interesting in the Philippine context. That okay, and it's interesting. Also, I would like to also note that even if we have the Data Privacy Act, etc., like I think in Brazil, even if we had the law already in 2012, the implementation of this law and the awareness from the people is not that strong. Imagine it has been existing since 2012. It has only been recently that there's been active and proactive advocacy for data protection and data privacy. And yet we are still, hanging by a thread, or, there's still problems in implementation or awareness from the public, how important it is to shield their data protection. And even so, that even if this is even the case, when the contract tracing app is supposedly voluntary, but nowadays, if you want to access certain public government offices, you need that app. You need to install that app. You need to comply with that app before you can enter. So it's already a quasi-mandatory kind of app. So it even strengthens even more the questions or the repercussions that arises on privacy and data protection. So yeah.
Okay, thank you. This was, in fact, of course, not exactly similar to other country experience. I mean, not Croatian and Netherlands experiences, and of course, similar. With respect to certain awareness issues and certain transparency issues, and of course ambiguity issues, but the entire nature of the absence of a voluntary figure with respect to this app it's missing. It's a miss. I think that this is a great way to segue into our next and possibly short section on further discussing the legitimacy of everything that is going to be done. Right. The entire point of having a structure to limit any kind of human right is to have it grounded in certain laws, certain legitimacy basis. We have, of course, the Philippines giving us a state of emergency. And this is, of course, connecting very well with Mr. Rafael Pangalangin's question that he has raised, right? So I'm just going to say it for the audience as well. Which of the countries reported emphasized a militaristic approach to COVID-19? For example, a military personnel for the war on COVID. So I would, of course, think that you have Dr. Angela specifically mentioned this in your analysis, right? I would invite the other panelists to further reflect on the question, and if not a war on COVID, what are the other legitimacy grounds that have been violated, let's say not really taken into account, because COVID is, fighting COVID is like fighting a war. So
should I start? Okay, so I think the Philippines is a prime example of someone who had declared a war against COVID-19. It has been very clear from the start that the securitization approach from the Philippines, that they treat COVID-19 as a security threat. It's not actually something new for a country to do that, because when SARS, the first strain of SARS, emerged, it was already also the reaction of certain countries. So, and then about the question of legitimacy, it is my opinion that the law and it's the basis for the actions, the measures enacted by the government are legitimate if you base it on the law in the books, because they have every legal basis to back their actions. They have the Constitution to exercise emergency powers. The Congress has granted it to the president to exercise emergency powers, and if needed, take over public utilities and other medical facilities. So, and for a certain period of time. And then there's also the oversight function of the Congress to see if the executive or the president has done a good job. So there is a legitimate base on that. And then there you have the enacted laws on the Bayanihan to act as one and the Bayanihan Act to recover as one, which provided a list of special powers provided to the president. So he could address not only the health concerns, but also the public order and safety concerns in the Philippines against the arising from the COVID-19 problem. So legitimacy based on law, I think it's there. The problem is implementation wise. So if we talk about as well as Data Privacy Act, there is also, somehow the standards are there. But when respect to, the nitty-gritty, the implementing rules or the regulations or the ones implemented in practice, that's where the questions of legitimacy arise, because you can see that they're using this legitimate, quote unquote, legitimate measures to enact their abuses, their misuse in implementation. So that's the problem, as well as and then you see that this legitimacy is also apparent with respect to the task force itself. You see that it's not only the Department of Health that is concerned. We have the National Defense Secretary there. We have the Philippine National Police there. We have the military and the police working together in checkpoints. So the COVID-19 is not solely a health issue. It has military and police law enforcement measures as well. So, and then this is so this commixtion of this health plus military police measures, this creates, in my opinion, this fog of war that, okay, we're addressing the COVID-19 problem. We're preventing the spread of the infection, of deaths and casualties from COVID-19. But at the same time, this is also, I think that some abusers of this power are using it as an opportunity, to implement, their ulterior motives against their detractors, against those who go against the government. And it's so state-centric, to be honest. It's so state-centric, and it seems that the state is showing that they have the monopoly of truth or effectiveness in addressing the COVID-19 issues, that anyone else who threatens to expose fallibility of the government's plans is put at risk of being, prosecuted or persecuted for example, like false information or something. So that's how sensitive somehow. So the implementation is a problem. And second, there's like the onion skin government or local officials against onion skin against the criticisms that they may implement. And this has happened numerous times. It's not only against human rights activists, but other critics as well. So it's a phenomenon unique, I think, among all the reports submitted among the reports submitted, because you see, the phenomenon, the interesting phenomenon of being illegitimate in law, and yet when you implement it, it becomes questionable altogether. So the lawful means, but the measures, it's questionable, and it raises, like, you cannot help but ask, like, how do you strike then the balance, right? So yeah.
Completely understand. I would definitely like to invite Ms. Van Gils to react to the situation because she's analyzed it in her country report, although it's dissimilar to Philippines with respect to the legitimacy portion, I guess, but she definitely has an analysis similar to her to Ms. Dr. Angela's conclusion.
Yeah, so the Netherlands very much they did not take a military approach to the pandemic. The government has actually refused to use our military, um, um, except for when they helped in care homes during the first wave, all the medical military personnel, and they helped building new test locations. But other than that, they haven't really used the military. The Netherlands is a very, very liberal country. I think that is very important to note in this context. So our government tries to take a very democratic approach to combating the pandemic, which I think is very good, but also sometimes the dynamic is a bit off. So during the first about 10 months, most measures were based on local emergency ordinances, which were in their case based on the Public Health Act. So the Public Health Act delegated powers to, for example, mayors and aldermen and ministers to take certain measures to combat the spread of a virus. But the emergency ordinances are allowed. They can technically interfere with basic rights and freedoms, but only for a limited amount of time. So, for example, if there's a gas leak in the street, the local authorities should be able to evacuate everyone and prohibit them from entering their homes, of course. But these emergency ordinances, after a couple weeks, they were heavily condemned because after a certain amount of time has passed, they weren't they weren't a sufficient legal basis anymore. They were at the start, but after time had passed, not anymore. The government did not declare a state of emergency. I don't think that would work in the Netherlands, where people are very much used to very far-reaching rights and freedoms. Also, there were already democratically legitimized laws in place to provide for the local emergency ordinances in the beginning. We had the Public Health Act, which stated they could take emergency ordinances in case of a pandemic. In the beginning, it wasn't really necessary to invoke a state of emergency. And in the beginning, it was such an exceptional situation. No one knew how long it was going to last. So in the beginning, the government thought that these emergency ordinances were sufficient enough. But then after a while, of course, after the criticism, the government started to work on a new bill relating to corona measures, which entered into force in December. So I think it's very good that they are taking the democratic approach to combating the virus. And also, for some countries, a state of emergency can be used to release more funds, as we have heard in the United States, for example. But in the Netherlands, that's not really necessary because our treasurer, fortunately, had sufficient reserves. And also the state is, of course, borrowing money together with the EU. So a nationwide state of emergency wasn't necessary and does not really fit into like the political culture, the liberal culture of the Netherlands. And we also have a very liberal government at the moment. So I think that's why they refuse to take that military approach. I don't think that would work in the Netherlands. So yeah.
Noted. Thank you so much. But considering you did take us to the direction of emergency funds, etc., I would definitely like to invite Mr. Becker to talk about, and in a short format, of course, because we're running out of time, but talk about the emergency aid issue that you've highlighted in your report with respect to certain other privacy issues that you've connected it to.
The what you call auxílio emergencial, which means like emergency help or emergency aid, was a very interesting program developed by the federal government here in Brazil to provide means of survival, especially during the beginning of the pandemic when everything was on lockdown. A lot of companies were shutting the doors. And however, since it's partly digital, we have a hard problem here with digital inclusion of poor people to the that don't have access to the internet. And adding this, there was a long queue for those people that couldn't access the internet to subscribe to this emergency aid. And of course, there was a lot of fraud involving this emergency aid. A lot of people that wasn't entitled to receive it, and a lot of people had their information or their cash that they received stolen by digital means. And it, of course, it deals especially with digital education. A lot of phishing started to be made during the pandemic, and it connects with the what I spoke before in the last round, that Brazil doesn't have this awareness regarding data protection and privacy. So it is a mean of education, no doubt. And of course, every welfare program you have fraud. Even in Europe, you have fraud in the welfare programs. But the situation here was worse, especially because of this digital education issue.
Okay, noted. Uh, so now I think we can direct ourselves to Ms. Alina so that Ms. Alina could further talk about the cyber threats issues that she highlighted, and which I do think that other countries did in fact face and reacted to differently, as has been noted in her report. So could you provide us with a comparative analysis, let's say, of how exactly Croatia should have reacted in such a situation, right? Because we do see that Netherlands, of course, did not have a hacking issue of the sorts, but in Brazil, something similar happened, and you've claimed that this has also been happening rampantly in Croatia. But they should have had a very different approach to it. So could you further elaborate on that in a short summary, of course?
Yes, of course. So here's like first to give you a bit of introduction about the regulation of cybersecurity in general in Croatia. I mean, we are a member of the European Union, so NIS directive and all other documents are in place, other regulations. So the cybersecurity regulations, like a legislative outline, exists. I think that in general, the main problem is that we lack public awareness about the cybersecurity, and we certainly lack cybersecurity experts. So I think that our agencies and regulators are in general not quite active in cyber area, and perhaps because we until recently have been a quite cyber secure country, so there weren't many major cyber threats or cyber attacks in Croatia. We had a huge attack in 2020 on our major oil and gas company. But I think the situation changed with the GDPR, where there is an actual liability for data breach that resulted from the breach of data security. So I think that at least companies are more aware of the cybersecurity, and they care more about the implementation of sufficient cybersecurity measures. But what I saw as a problem during the COVID-19, I mean, even now, it's the lack of the public awareness. So let's just start with the remote work, with the major shift to home offices. I'm on my private computer at the moment, and I use that computer for work also when I work from home. So there are many employees who use their private networks, their private computers for the access to company server. there is also an increase in distractions during the workday. So you are at home, you have children or pets or anything, you have to make yourself something to eat. So there are many, many distractions. And such an environment, I believe, creates really, really good opportunities for cyber attackers. And what, of course, companies are primarily responsible for implementation of cybersecurity measures, that's for sure. It's on them to, introduce sufficient VPN tools, double authorization, so to prevent as much as they can any breaches into their networks. But I also believe that each person bears its own responsibility, and in an environment such as remote work, we are less careful. So that's why we see the increase in phishing attacks, and also in ransomware attacks. There was a huge ransomware attack on the hospital in Germany, during which one person died because of the attack. So what I think we lack in Croatia is a response from government agencies and agencies is in charge of cybersecurity, to publicly stress such alertness and such threat, to raise, to raise the alertness about the cybersecurity. So what I saw in other EU countries, and as well in some neighbor countries like Slovenia, their agencies published guidelines. I mean, it's guideline, it's not an official law, but it does not have to be. We have law in place, so we have legislation. But what they did is, like, they published guidelines. So don't use communication tools which are not secure. Use double authorization. So they introduced specific measures that can be implemented both by companies and by individuals, so by each of us, to secure our networks and to avoid cyber attacks as much as possible. So I think that that is what I realized with regards to Croatia. We have the law, but implementation is really dubious, and we lack public alertness about the cybersecurity.
Right. Okay, thank you. Thank you so much, Ms. Selena. So considering we are really short on time, I would invite the panelists to, in a very short summary, perhaps a minute, react to what other countries' experiences were and what resonated with them with respect to what the other panelists have said. I would also like to invite you to answer to Professor Rafael Pangalangin's other question regarding the Child Rights Convention as well. So yes, any of you can begin, of course, with respect to your concluding remarks and reaction.
I can start if that's okay. So I already thought that the Netherlands' approach to the situation has been generally okay, specifically because it's very much democratic based approach, and especially after hearing the measures of the Philippines, I think the Netherlands is doing really well, and it's sometimes it sounds a bit nitpicky to even have much criticism on the Dutch approach. So yeah, I think in the Netherlands, the privacy concerns do not stem from improper privacy legislation or improper care by the government. It's mostly unawareness and negligence. Yeah.
Okay. Who wants to go second?
Maybe I can.
Sure.
Okay. So that we have enough time. So I think so the problem that arises from the Philippine situation. So I try to contextualize it in a securitization approach, because that is basically the approach taken by the government against COVID-19. So, and the problem that stems, so the problems that I highlighted in my report stem from this securitization itself. Per se, securitization is not bad. It's not a problem. But the problem arises, or the issues arises, from the implementations of the measures in the Philippines. So the implementation wise, problems arises because there has been misuse or abuse of the powers given to the executive department or the local government officials or those law enforcement officers who needed to implement the measures on the ground. So that's the problem, the implementation. And somehow this entire securitization approach. So the Philippines, I think, is a good example on the perils of securitization of COVID-19. That there are repercussions on human rights, on privacy and data protection, especially if you don't have parameters that are well implemented on the ground. If you don't have the social controls that you need to avoid delinquent behavior from the law enforcement officers themselves or the government themselves. So, and that there is the danger of securitization to provide this needed blanket or fog of war for, government officials to abuse their power and, to perpetrate violations of human rights, of data privacy, and data protection and privacy. So with that, I think not only again, I think in the Philippines, I mean, we take these measures against COVID-19 somehow as mundane. Like most of the time, we take it for granted, the measures implemented on the ground or enacted by our governments. But I cannot find the right word to choose, but maybe we should remain vigilant and aware of these measures being implemented or enforced, because it is only when we are aware of where we are aware and knowledgeable of these measures and the repercussions that can arise from these measures, then we can truly act and avoid any further abuse or misuse of these measures. So thank you for the time that an opportunity to be able to share my insights on this situation.
Thank you so much. Can I invite Mr. Becker to now provide his concluding remarks and reaction?
Thank you. I think the most interesting thing about Brazil is that even though Jair Bolsonaro, our current president, elected himself with a speech supporting the militarization of the country, as enthusiastic of the dictatorship that took place in Brazil during the last century, he reacts very negatively regarding the initiative by mayors and governors of the states in Brazil of lockdowns and emergency measures, alleging that they are trying to implement a dictatorship. So it's kind of contradictory. So as a lot of presidents and leaders around the world, our president, unfortunately, is doing everything he can against the contention of the virus. And one interesting thing, just to conclude, is that we should remain vigilant, as Angela said, because our data protection authority has 50% of the board are military officers. So it's a very worrying situation, and I think that's it. And we should follow the next episode of Privacy Brazil. Thank you.
Thank you. Thank you so much, Mr. Becker. Can I now invite Ms. Alina Skilhick also to talk about her experience, reaction, and concluding remarks?
Yes, thank you. Well, overall, Croatia did a good job in dealing with pandemic. We really haven't taken a military approach. We actually, I mean, Croatia cared about the human rights, so both about the privacy. So there are no many direct infringements of privacy law. So we cannot claim or argue that Croatian approach to coping with pandemic has resulted in major, violation of personal data protection and privacy. But the main problem is the loophole in regulation. So that's what we did wrong. We did not regulate. And as a closing remark, what I would like to say that really the government, the public authorities, the civil protection, they tried to regulate it, to provide guidelines, but in a wrong way. They made all the guidelines in a recommendation form, which I think was incorrect. I believe that the better approach would be that they introduced mandatory laws, or at least ordinance, or regulations, which could then serve as legal basis for data processing, and which would make the control of data processing and collection practices easier and better. But instead they did everything in a recommendation form, which is why we see that both the authorities, the healthcare industry, and the private companies struggled with identifying legal basis and with complying with the GDPR. So I think that the lack of regulation was not good. So that was the main issue. But other than that, I think we did good. We did a great job in dealing with the pandemic.
Thank you. Thank you so much. This was, in fact, a thrilling experience to learn from very different countries on how best to or how not to approach the pandemic. And of course, every country has done something right and something wrong in this unprecedented situation. But I would definitely like to thank the panelists for very coherently figuring out what the best approaches were and what the bad approaches were with respect to this issue. I would also like to thank the Institute for the Internet and Just Society so that we could have this conversation in the first place. Thank you to all the panelists. Thank you to the Institute. And this was really lovely. Right. Okay, I think